Does the Sixth Amendment also discuss the requirement for an impartial jury in the area where the crime was actually committed?
Correct. The Sixth Amendment gets at jury issues and tells us a little bit about needing an impartial jury. The notion is that the jury should be a jury of your peers, although that has been a misnomer through the years. A jury of your peers doesn't necessarily mean people who look just like you. It just means a group of citizens who are chosen appropriately for the task of being jurors.
So let's talk about, in more detail, the right to trial by jury. What is the extent of the right? What are the purposes and assumptions underlying it?
The right to trial by jury is a right that in some ways has been somewhat misunderstood. The prototypical way we think of a jury is 12 people, unanimous decision, that's the way we do it. It actually turns out that the right to a jury trial is in fact a right to a jury trial, but there are a couple of different ways that we can deal with a jury. A couple of assumptions that underlie the jury. We want to have 12 or some reasonable number of people so that we can get a cross-section of the community. The jury's role in the criminal justice system is complex. The jury can act as a check against abuse or misuse of power by the government, or act as the conscience of a community. However, what qualifies as misuse of government power or what qualifies as acting as the conscience of the community can be contextual. A jury that declines to follow the law may appear to be a defender of ultimate justice in the Zenger trial, but may appear to be an organ of injustice when acquitting those who harmed or killed civil rights workers and others in the 1950s and 1960s.
Can it be less than 12 in a criminal trial?
Indeed, in a criminal trial, you may well be able to have less than 12 under certain circumstances, as long as you're not talking about capital offenses, issues along those lines. So in certain circumstances, you can have fewer than 12. In certain state circumstances, federal circumstances, different story. But in state circumstances, you can have less than 12. And in some circumstances, you can have a non-unanimous jury. As long as you're not talking about a capital jury, a capital crime, there are circumstances where you can have as few as 10 out of 12 jurors vote for conviction and have the conviction upheld. The idea is we want to make sure that juries can suggest that it's pretty clear that an individual is guilty. That might seem to require unanimity, but the suggestion is that there are certain circumstances where a little less than unanimity is sufficient for the government to say, we think this individual ought to be punished. Now, that's a rare circumstance. In most circumstances, you're still talking about 12 jurors with unanimity. Suggestion, though, is that it's not necessarily constitutionally required that every jury have 12 and that every jury be unanimous before we have a finding of guilt.
What actually triggers the right to a trial by jury? Is it a criminal offense, a specific kind of criminal offense?
The right to trial by jury is one that comes, largely speaking, with crimes that are not petty crimes. If you're talking about crimes that have no jail time or a very, very small amount or just fines, then you may have some circumstances where you don't necessarily have to have a jury trial. But any crimes that have more than, I believe it's 6 months possibility of imprisonment and anything more than that, then you're talking about having to have a jury trial if that is what the defense requests. Now, the right to a jury trial is one that can be waived. So in certain circumstances, you can have a bench trial, which is a trial directly by the judge who serves as the fact finder and the lawgiver in those circumstances.
You mentioned proof beyond a reasonable doubt. That doesn't always require a unanimous verdict. That's what you said, right?
That's correct. The proof beyond a reasonable doubt is for each juror to say and to find that there is proof beyond a reasonable doubt if they're going to vote to convict. But it's not always the case that all jurors have to vote to convict in order for there to be a guilty verdict.
What are the qualifications someone must have to actually sit on a jury?
Citizenship. Over time, it used to be that we were far more limited, that not only did you need to be a citizen, in certain circumstances you needed to be a man, in certain circumstances you needed to be white. So those have changed over time. Now, essentially what we're talking about are citizens who live in a particular area may well qualify. Now, you may have some limitations, for example, limitations based on whether folks have prior crimes, have committed prior crimes, issues along those lines, but generally speaking, we are far broader in terms of who can serve in your jury pool. Now, we do have some rules that may allow folks to stop individuals from actually serving on a jury. Whether you're talking about challenges that may be made to people, or whether you have rules that say, for example, allow individuals to dismiss lawyers from jury pools, issues along those lines. There are some states that have those, but generally speaking, if you're talking about citizens not convicted of crimes above the age of 18, those are most of the limitations on who can be on a jury.